كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. My dear beloved brothers and sisters, dear students, alhamdulillah, we are on lesson 2 of the da'wah and bayyinat of judicial law in Islam. So yesterday we discussed the conditions for bringing a case, how it's brought, the necessary conditions for that. You have to be able to define your case, and it has to be very, very clear, and then the basic process we discussed. So today, inshallah, we're going to continue with the discussion on the process. So we got to the situation where the claimant had made his claim and couldn't provide proof. If he provided proof, it was very clear, it was done. If he couldn't provide proof, then we had moved over to the defendant and asked him to swear an oath that he doesn't have that this case is wrong and he doesn't owe anything based on whatever is being charged. He is completely innocent, and so on and so forth. So that's where we were with this discussion. So inshallah, in today's lesson, we'll complete that discussion and move on to some other discussions with that. So it says that وَلَا تُقْبَلْ بَيِّنَةُ صَاحِبِ الْيَدِ فِي الْمِلْكِ الْمُطْلَقِ. Now, Sahibul Yad, right? I'm going to clarify that for you. Sahibul Yad literally means the person with the hand, the owner of the hand. And Yad in Arabic also refers to possession, like it's in my hands, meaning it's in my possession. So what you have sometimes is that you have a case that you owe me, that laptop is mine, or that phone is mine, that pen is mine, but it's actually in your hand. You see it being in your possession, or it's in your possession. So what we do in Islamic law through the judicial system or otherwise is that in order to determine, in the absence of proof, where there's proof, it's going to be very, very clear cut. We'll have to go according to the proof. Where there's no proof, like clear proof, definitive proof, then we take whatever we have. And sometimes the only evidence, so-called loose evidence we have, is that, it's in this person's possession. He's had it for the last 5 years, for example. Now, while that doesn't have to be proof, because he could have usurped it 5 years ago, but the fact that nobody can prove that being in somebody's possession is sometimes evidence, but it's a very, you can say, it's actually not a very strong evidence. It's a very, very light evidence. It's a very, very weak evidence, and it can only be used and resorted to when there's nothing else. So inshallah, we're going to have this discussion today. So to start off with Imam Quduri's text, he says, actually we were going to quickly finish off a discussion on the hadith related to this particular chapter of fiqh. So one was the hadith which we mentioned in yesterday's lesson at the end, is that the evidence and the proof is upon the claimant, and the oath has to be sworn by the defendant, and we don't mix that up in the Hanafi school. There's another hadith which is used by somebody, by the Shafi'is and others, al-shahidu wal-yamin. Right, al-shahidu wal-yamin, essentially it's a hadith that has been transmitted by Imam Muslim from Ibn Abbas radiyallahu anhu, that anna Rasulullah sallallahu alaihi wasallam qada bi yaminin wa shahidin. The Prophet sallallahu alaihi wasallam did rule according to an oath and a witness. So took one witness and one oath and considered that equivalent to 2 witnesses, and that was enough. Now the hadith, the Hanafis, they don't agree with the purport of this narration, because they say that it goes against a number of, for example, verses of the Quran, which refers to there having to be witnesses in terms of wealth issues, in terms of claims of wealth. It has to be shahadat. We need proof. We don't just go with an oath in that. We need proof in that regard. Also, the hadith previously, which is a mutawatir hadith, they say, which is a very widespread narration. The previous one that we mentioned, which is that the oath is upon the defendant and the proof is upon the claimant. So that's a very, very important hadith that is contradicted by this narration. So that's why we're going to go with the former narration and not this narration. Okay, now coming back to the discussion of the person who has the possession of something. So he just decides to mention here that وَلَا تُقْبَلْ بَيِّنَةُ صَاحِبِ الْيَدِ فِي الْمِلْكِ الْمُطْلَقِ. If there's somebody who is just claiming that this is mine, this is my possession, this is, sorry, my ownership, I own this. So you've got two people. One person is saying this is my ownership. The other one is also saying that, and person B actually possesses that that article, that piece of goods or whatever it is, right? So the fact that he's got the goods in his hands, he's saying that his proof, any proof that he provides will not be accepted because he already has the possession, and this is only in al-milkul mutlaq, he says. So this needs to be a bit unpacked. Al-milkul mutlaq, which means unqualified wealth or default wealth, right? So he's saying that, for example, somebody, person A, is claiming that I own this laptop, right? And he doesn't mention how he owns it. So that's the point here. It's milkul mutlaq, means he's not mentioning how he got it. I just own it. How did you get it? Did you buy it? Was it gifted to you? Did you rent it? What is it? So he doesn't mention any sabab. He just mentions that this is mine, right? That this is milki, hadha milki. He doesn't say that he bought it in any way. So he's saying that in that kind of a case, they're not going to accept his, they're not going to accept any proof that comes from him, because he's already got a proof in the sense that the thing is already in his possession. That already shows that he's got some ownership. So for him to add a proof to that doesn't really add anything. So if there's a the third person, person B, for example, who doesn't have the possession, is also claiming, and he provides evidence, then it's actually going to be given to person B, right? Away from person A, who had the possession of it, even though they're both providing proof. Because when two people provide proof, clearly there's some problem there. So it shows that the person who's actually adding extra over and beyond is person B. You might think it's person A because he has the possession plus he's providing proof, saying that no, once you have possession, then proof upon that doesn't really add anything. That's what they're saying, right? So that's why he's saying لأنها لا تفيد أكثر مما تفيده اليد فلو أقام الخارج البينة. Whenever in this chapter you see the word kharij refers to the third party who doesn't have possession. For example, usually that's what it refers to, right? كانت بينته أولى. So that third person who doesn't have possession, his proof is going to supersede the proof of the person with the possession. لأنها أكثر إثباتا, because that's actually proving something, whereas the other one is just corroborating something. It's not proving anything, right? And it's showing that he must have it because there must be a reason why he has proof. And of course the proof has to be of a certain quality, certain category. So it shows that if he's got the proof, then if he's got proof and he doesn't have possession, it means that it must be his, right? Okay, now that would be different if it's not a milk mutlaq, as we said. It's not just general ownership that he's claiming, but he's actually claiming ownership based on the fact that it was, for example, a goat that was born, right, or a horse that was born from by him from another horse, right? It's the kid, right? It's the small horse, baby horse that was born from him. That would be dealt with differently, which I'm not going to go into right now. Right, now let's get back to the main issue. I just mentioned that because Imam Quduri kind of throws that in between, right? Let's move over to, actually, you know what, let me just explain it, otherwise, you know, it might as well explain it right now. So for example, there's somebody who is claiming a goat, a kid of a goat, or let's just say a horse, a baby horse, right? Now the person who actually has it in his possession, he's actually claiming not just that it's mine, as in the previous case, he's actually claiming that it was born by him from another horse. Obviously it was the offspring of another horse by him, right? So they both are providing some kind of evidence, but this guy is providing an ذِلْيَدْ أَنَّ هَذِهِ الدَّابَ نَتَجَتْ عِنْدَهُ وأقام البينة على ذلك. They both provide evidence. ولأحدهما يد, but one of them has the possession of it as well. فإنه يقضى لصاحب اليد. So in that particular case, it will be judged to be the ownership of the person in whose possession it is. So just to conclude quickly, if it's just a claim of this is mine, this is mine, this is mine, then, and they both parties are providing evidence, then it's gonna be given to the person in whose possession it is not, because he's actually establishing something. The other one is just corroborating something. So it means that there must be something that person B has who doesn't have it in his possession that shows that it is his, right? Whereas in the case of where it's not just about claiming something is mine, but claiming something is mine based on a particular reason, then as long as they both are providing evidence, then in that case, the evidence of the person in whose possession it is will take precedence. So essentially what we're learning here is sometimes you'll have a case, right, where both parties provide evidence. So then it becomes a whole series of understanding whose proof we're going to take, whose evidence we're going to accept, right? And there's lots of cases like that which we'll do in detail. But let's get back to the issue of وَإِذَا نَكَلَ الْمُدَّعَ عَلَيْهِ عَنِ الْيَمِينِ. So the person, the claimant, did not have proof, so it turned over to the defendant. Where's do you agree? No, I don't agree. I don't owe him anything. Okay, swear an oath. But said, I'm not going to swear an oath. That's where we've got to, right, in detail. So وَإِذَا نَكَلَ الْمُدَّعَ عَلَيْهِ عَنِ الْيَمِينِ. If the defendant refuses to swear an oath, قُضِيَ عَلَيْهِ بِالنُّكُولِ. Now the judgment will be made upon him, against him, based on his refusal, right? وَلَزِمَهُ مَدُّئِ عَلَيْهِ. And obviously whatever the claim is will become binding upon him. I think that's quite straightforward, because he refused to swear an oath to defend himself, right? He wasn't willing to swear the oath either because he genuinely does own the person, owe the person, or he has some other reason. But whatever, he's decided to go that way. You have to remember that. He's decided to go that way. Imam Maydani just meant لأن النكول دل على كونه باذلا عنده. Imam Maydani mentions that by him refusing to swear an oath, he's giving up on the case. He's not defending himself. He's willing to just pay for it now, right? Either because he genuinely does owe the person, or he wants to just relinquish his right, right? He just wants to relinquish, and he doesn't want to swear the oath for whatever reason, or he just wants to do it and get it over and done with, right? Just to make it easy. It could be either way, whatever it is. So that's essentially what it is. So in Arabic they use the word baadhilan, that he's willing to relinquish it for whatever reason. I mean, it doesn't mean that he's guilty, but guilty in the sense that he actually stole it. It just means that he owes the person now, because that's all you can prove. The only way you can prove that he actually stole it is if he said and confessed to it. But he didn't confess. He just refused to swear an oath. So we can make a judgment against him, but it doesn't mean that he is guilty in the sense that he actually did steal it, because he could have other reasons of why he's agreeing to say that. Okay. Because if he, so he's relinquishing it. The other option would have been that he should have just admitted it, but he's not willing to admit it, so he does it another, because if he admitted it, then that means that he is guilty, right? Okay. So he hasn't admitted it, and he hasn't sworn the oath, so there must be a third reason for that, right? Okay, then he carries on. ولكن ينبغي للقاضي أن يقول له. There's a procedure for this, right? He doesn't just get him to just swear the oath willy-nilly like that. The judge has to say to him, إني أعرض عليك اليمين ثلاثا. I'm going to present for you to take the oath 3 times. If you take the oath, then it's done, right? Then the case is out of court. Then great, wonderful, right? وإلا قضيت عليك بما ادعاه. Otherwise, I'm going to give a judgment based on whatever he has claimed, if you're refusing to swear the oath. So I'm going to say this 3 times to you. I'm going to present the oath to you 3 times. So that's just to make sure that he's understood properly and is clear what he's about to do. So this warning to him, right, is to give him an understanding that, look, this is what's going to happen. If you refuse to swear the oath and I'm going to present it to you 3 times, then we're going to make the judgment against you, and then whatever he is claiming is going to become binding upon you, right? Because, you know, somebody might not know what's going on in court. So that's why it's very important for the judge to say this. And it's not necessary for him to say this 3 times. It's just good practice to say it 3 times. Otherwise, he can say it 1. فَإِذَا قَرَّ الْقَاضِيَ الْعَرَضَ, when the judge repeats this and presents this oath to him 3 times, and he refuses, then he can make the judgment that, okay, he's refused, so he must be he must be liable. In other books, it's not mentioned in Quduri, but in other books it says that only some scholars like Khassaf, Imam Khassaf and others have mentioned that he should say this multiple times, just to make it just for precaution. Otherwise he can do it once, and he can judge against him if he just refuses once to take the oath. He doesn't have to present it to him 3 times. Now, how is he going to refuse to take the oath? Well, he could just stay silent, right? But another one is he could say, La ahlif, I'm not willing to take the oath. I'm not going to take the oath. So that would be obviously a real refusal, right? That's a real refusal, because I'm not going to take the oath. On the other hand, he could just stay silent and just play dumb, right? Or just stay silent. That still, legally speaking, is a refusal, right? Because in court you have to speak up. So unless, of course, it's known that the person has some kind of defect, right? The person can't speak, or the person has some other kind of deafness, he can't hear you, for example, then of course that's an excuse. Then you do it a different way. Then he says, وَإِنْ كَانَتِ الدَّعْوَى نِكَاحًا مِنْهُ أَوْ مِنْهَا. Now this is going into a different case. It's not about claiming some wealth, but it's about claiming that you are my wife, meaning I married you, you married me. So whether it's a wife, a woman saying that to a guy, or a man saying that to a woman, right? Either way, right? So one is person A is claiming nikah with person B, and person B is refusing, and they could be male or female either way, right? In that case, obviously bring proof. If you can't bring the proof, then what happens in that case? He's saying that in that case, lam yustahlaf al-munkiru minhuma inda Abi Hanifa. Imam Abu Hanifa says in this case, it's a special scenario. In this case, you can't get person B, the defendant who's denying the marriage, you can't get them to swear an oath. That doesn't work in this case. It's either proof or nothing, right? Because you see, as I explained last time, that when somebody refuses, what they're doing is they're relinquishing their right to fight, which means that it's either because they're guilty or because they're not guilty. But in this case, if they're relinquishing the right, does that mean they are married, right? وَالْبَذْرُ لَا يَجِي فِي هَذِهِ الْأَشْيَاءِ الْمَذْكُورَةِ. Whereas in this case, you can't really, because it's either you are married or you're not married. So until now, you may not be married. Now a judge might make a judgment to get you married, right? But it's a very different thing to claiming some kind of an item, right? Rather than nikah. Nikah is not something that you can relinquish in. So that's why in this case, you can't ask them to swear the oath. وَلَا يُسْتَحْلَفْ. That's why he says, وَلَا يُسْتَحْلَفْ فِي إِنْكَارِ النِّكَاحِ. Right? If he refused that, no, I'm not married, or she refused that, no, I was not married to him, right? I have no nikah with him. They cannot be told to take an oath. Likewise, they can't be told to take an oath in a revocation. So the husband had, the husband had given a divorce, and then after that, there's a claim either by the wife or the husband that I took you back, or she says you took me back, and I'll say no, I didn't take you back, or you didn't take me back, right? After the iddah, as long as this is after the iddah, this one only refers to after the waiting period is over, then in that case you can't make them swear an oath, because in this case it won't play out, right? And likewise it says وَالْفَيْءُ فِي الْإِيلَاءِ, whether there was a return and he did ila with his wife, right? Which is a particular way of saying something to his wife, I'm not going to be with you, and so on. Anyway, I'm not going to go into that. People don't usually do that much. وَالرِّقِّ وَالْإِسْتِيلَادِ. This is also the same thing Imam Abu Hanifa says in the case of a manumission, freeing a slave, and the person says, no, you did not, or rather the slave is saying that you freed me, whereas the master is saying, no, I did not free you, right? He won't be made to swear the oath if there's no proof on the other side. Well, istilad means that this is to do with concubines. To become istilad means that she becomes the mother of a child of the master, right? It can't be in that case either. right? وَالنَّسَبْ وَالْوَلَى. Likewise, you can't do this in the claim of genealogy, right? Ancestry from somebody, right? And likewise in wala. Wala is, you can say, clientship of freeing someone, that you're claiming that I freed the person, so I should receive their wala. So because they don't have any connection with anybody else. So if they die, this person gets their inheritance, so on, so on. So it's a claim about that, right? And then he says, وَالنَّسَبِ وَالْوَلَاءِ وَالْحُدُودِ. And likewise in penalties, right? In penalties, these are hudud, these are these punishments that happen, where the cutting of the hand, the flogging, and so on. In all of these things, if there's no proof, you can't go to the other side and swear an oath, right? And make them swear an oath, because remember, when they're swearing an oath, that's not that's not 100% proof. That's just a way to get out of it, right? And in all of these kind of cases, or at least in the hudud, you can't legislate had on somebody, which means the cutting of the hands or whatever it is. You can't legislate that on somebody when there's any doubt. And this second phase of refusing to swear an oath, that is not considered a very, very strong evidence, right? It is enough to make a judgment in many cases, but not in hudud. Sahibain, which means Imam Abu Yusuf and Imam Muhammad, they have a slightly different opinion. They say yustahlaf al-munkir fi dhalika kullihi. All of these cases, it will be normal. So the defendant will be asked to swear an oath, except in the last case, which is in hudud, in penalties. In that one, the reason is that Imam Abu Hanifa, as I mentioned to you, whenever a person refuses to swear an oath, they're just willing to relinquish their right. That's what they're showing. Whereas according to Sahibain, they actually see it as confession. For anybody to refuse to swear an oath, they see that as confessing that I'm guilty, that I'm wrong, that I do owe him. That's what it is. لأنه إقرار عنده, right? والإقرار يجري في هذه الأشياء. He says that in all of those particular cases, you can have iqrar, right? So that's why we're going to say that you will ask them to swear an oath, except in hudud. When it comes to the hudud, which means these judicial penalties of punishments, they're taking the refusal of swearing an oath to be a confession is actually full of doubt. It's vague. It's not clear. Yeah, if he clearly confessed, that's different. There's a procedure for that. But he didn't clearly confess. They're just treating it as a confession. He just refused to swear an oath. They treat it as a confession, but it's a weak confession. And because there's a doubt in there, you're not allowed to apply these penalties, right? Wherever there's any kind of doubt. So that's why that won't work. And what Imam Maydani does is that, and you can check this out for yourself, he actually, wherever there's an ikhtilaf, he actually mentions whose opinion is stronger. So I'll mention it here. I won't mention it anyway, because we've got to get through a lot. And if you did want to check, you could just check in the Lubab. So the later scholars, they kind of reconcile between the opinions. They said that if the judge looks at the case of the defendant, and if he sees that he's just some stubborn guy who's not willing to play along, and he's not, then make him swear an oath. So go by the Sahibain's view with that. And so go by the Sahibain's view. And if they see that he's actually kind of more on the oppressed side, and it's the claimant who, maybe has some problem, so then in that case, don't make him swear the oath. So they've used both opinions to be applied in different contexts. Okay, to move on now, into now cases where, for example, let's just say that there's two claims that come in and things of that nature. وَإِذَا ادَّعَى إِثْنَانِ عَيْنًا فِي يَدِ ثَالِثٍ. Let's just say person C possesses a laptop or a phone or a nice pen, and there's two people who are claiming that it's theirs, right? So إِذَا ادَّعَيَ إِثْنَانِ عَيْنًا فِي يَدِ ثَالِثٍ. There are two people who are making claims for that specific item that is in the possession of that person C. وَكُلُّ وَاحِدٍ مِّنْهُمَا يَزْعُمُ أَنَّهَا لَهُ. Now it's not they're saying that we jointly own it. They're both claiming that it's ours. So it could be two brothers. It could be an inheritance issue. No, it's mine. No, it's mine. Person A, B, they're both saying it's fully mine. Each of them are saying that. يَزْعُمُ أَنَّهَا لَهُ وَأَقَامَ الْبَيْنَ. Interestingly, they both have proof as well. Sufficient evidence. They bring witnesses. قُضِيَ بِهَا بِالْعِلْمِ مُدَّعَى بَيْنَهُ. What do you think you're going to do with that? They both have evidence, right? So it's clearly, the third person doesn't have any evidence. He just has it in his possession. Somehow he's got it. Maybe their father had given it to him and he's claiming, they're claiming it from him, saying that it's mine, my father gave it to me and this is the proof and this is the proof and these are the witnesses. So very simple, because they both have proof, they're both equal, and you can actually have them both become owner. They're going to become half owner, 50-50 owners. That's why قُضِيَ بِهَا بَيْنَهُمَا نِصْفَيْنِ. They both are now partners in it. They both own it together. Because they both have proof. They both have similar witnesses. So they both have the same cause to have it legislated for them. So they both get it. Right? Half. وَإِنِ ادَّعَى كُلُّ وَاحِدٍ مِنَ النِّكَاحِ إِمْرَأَةٍ حَيَّةٍ. What about if there's a woman, C, right? And both of these guys are claiming that they're married to her, that A is married to her, B is claiming he's married to her. How can she be married to both? وَأَقَامَ الْبَيِّنَةِ. Okay, so it goes through the process. Where's your evidence? They both provide evidence and proof, witnesses. Now in that case, can you give it half? She's one day yours, one day no. In nikah, you can't have a split nikah. You can't have partnership in marriage, right? لَمْ يُقْضَ بِوَاحِدَةٍ مِنَ الْبَيِّنَتَيْنِ. You'll have to throw, they're both inadmissible. You're going to have to throw both of them out because there's no way to give preference to one over the other. وَرُجِعَ إِلَى تَصْدِيقِ الْمَرْأَةِ لِأَحَدِهِمَا. So what do you do in that case? Well, go and ask the woman. Now if the woman says, yes, it's actually person A rather than person B, then he gets it. He gets her. He is married to her. Or she says B, then he gets her. Right? Because really what's happening in that case is that the guy is agreeing that she's my wife and she's agreeing that he's her husband. So then it's like a nikah then anyway, right? So this is obviously the case where the two evidences that were provided, they had no date. They just said, yes, we know that he's married to her. We know that he's married to her. They both said the same thing. Then in that case, you can't really give preference. However, if they gave a date, person A says he got married on the 1st of July and person B says they got married on the 25th of July, then clearly the one who's older, they're going to get it, because by the time the second one did the marriage, based on the evidence we're getting, she was already married to the first one, unless they can prove a divorce in between or something. But it still wouldn't be allowed because, well, there may be some cases where that might be possible. But yeah, but the case is very simple here. They're just providing evidence of marriage and with dates. So the one with the earlier date, that's what it's going to be. Now, before they can provide evidence, if the woman was there anyway and she just said, no, it's that guy, then there's no evidence needed. It'll be those two. It'll be person A or B, whoever she says is her husband, that they will be married. Right? Now, if that's the case, then the second person B, for example, then provides evidence that she is married to me, really, and here's the evidence, and person A doesn't have any evidence, for example, but the woman had said person A is her husband, right? For whatever reason, there must be some problem here. Person B actually provides a certificate and the witnesses. He'll actually get her because his evidence is stronger than her confession, than just her confession, right? Because proof is very, very strong. Now, a bit of a more complicated issue, right? In that same scenario, let's just say only one of them made a claim. And the woman is saying, no, he's not my husband. And that person actually provided proof, brought evidence as well. So the qadi made a judgment between them that yes, they are husband and wife. Then person B comes and makes a claim afterwards. So they were not simultaneously claiming. And he also provides evidence now that she is his wife. There's already a judgment given. Now remember, this is a case now where a judgment is given and then another judgment is sought afterwards. That judgment will not be broken, because that first judgment was absolutely correct according to the procedure. They provided evidence and so on. So that's it. It's done. So that second person bringing the case in, it's not going to do anything because there's already a judgment. Unless the witnessing of the second person after the first judgment has been made, unless the witnesses there provide a date, right, which is earlier and proves earlier nikah than the first judgment, then in that case it just shows that the first judgment is wrong, because you've actually got evidence that this happened earlier than that one, right? There's a number of other cases as well. I might as well mention to you at least one of these complicated so you understand. Now what happens, it's going to be a similar case if the woman was already living with one of them. She was already with him, living with him, and the nikah was well known. Everybody knew that these were married. Then somebody else comes and makes a claim that actually, you know what, she's my wife. The judge is not going to look at that anymore, because there's already an established precedence that these two are person A with the woman is married already. So where's this guy coming from? Unless he's able to provide evidence that their nikah took place even before what is known of person A to have been married to her, then in that case there's only that particular case. Right, let's move on to the next part of Quduri, which is وَإِذَا ادَّعَى إِثْنَانِ عَلَى رَجُلٍ. So in this case we've got two people claiming against a third person. كُلَّ وَاحِدٍ مِنْهُ أَنَّهُ اشْتَرَى مِنْهُ هَذَا الْعَبْدِ. So this is a case, they give an example of a slave, that this person C sold the slave to them. So two people are claiming against him that he actually sold that slave that he has to them, right? They're both saying that I bought it. Person A is saying I bought it. Person B is saying I purchased it from this person. They both provide evidence. They got documentation and witnesses to show that, right? It's going to be accepted, right? And so it's going to be 50-50, obviously, because they both have equal evidence, right? They both have, of course, if one has evidence the other one doesn't, it's going to be his. But let's say they both bring two witnesses each, two male witnesses each. It means it's both of theirs. And this is not a wife, so it can be shared, right? So they both have a right to 50. Now this is very interesting. They both have a right to 50%. However, they're given a choice that do they want to take that 50% off? Because remember, they're claiming 100%. Each one of them is claiming 100%. But because they both have evidence, we have no way to give preference to one over the other. So it's going to be both of theirs, or they both have a right to it, but they may not want it now, because they might not want 50%. I don't want to be partnered with somebody. So they have a right to take 50%, of course, pay for it, take 50%, but then they also have a right to not take it. So this one is not binding, because it actually turns out that they wanted full, they're only going to get 50%, and whenever you wanted something fully, but you're now only receiving half or less than full, you get a choice to cancel, because they call that tafriqan lis-safaqa, right, which basically means that you're getting not what you fully wanted, so you have a choice to whether take it on or not. So they get a choice to take 50 or not. So let's just say one then gives up, right? The other one still gets his 50%, and then he can negotiate. He can't take the other 50% because that he didn't have an entitlement to it. That was the other person's entitlement. He let it go. So it's still the owner's. Now the other person can take his 50%, lay his claim to the 50% that he purchased it, make that effective, and then he can negotiate for the other half that the other person gave up if he wants to, and that's if the master wants to sell, right? Otherwise, he'll be a partner with the master if he so wants that. But he also has a choice not to have taken it as well. So hopefully that's clear. That's why he's saying, فَكُلُّ وَاحِدٍ مِّنْهُمَا بِالْخِيَارِ. Both of them have a option to cancel, essentially. إِنْ شَاءَ أَخَذَ نِصْفَ الْعَبْدِ بِنِصْفِ الثَّمَنِ. They can either take half the slave for half the full price, وَإِنْ شَاءَ تَرَكَ, they can just leave it because they're not getting the full amount. فَإِنْ قَضَى بِهِ الْقَاضِي بَيْنَهُمَا. Once the Qadi has made a judgment that it's for both of theirs, as he did, وَقَالَ أَحَدُهُمَا بَعْدَ الْقَضَاءِ لَهُ لَا أَخْتَارَهُ ذَلك. And the one says, look, I don't want it. Like, I don't want just 50%, so I'm going to drop the case. I don't want it. I'm not dropping the case, but I'm refusing to take it. I've got an option to cancel, so I'm going to take the option to cancel. لَمْ يَكُنْ الْآخَرَ أَنْ يَأْخُذَ جَمِيعَهُ. The other person doesn't have a right to take the other that first person's portion, right, by right. He doesn't have, because he only has a right in 50%, right? But of course, he can negotiate with the master to take the other half, and maybe he just wants to sell it off now, because there's no point having half of something. It gets confusing as to who's going to use in which day. You're going to have to make those decisions. Okay, next one. وَإِن ذَكَرَ كُلُّ وَاحِدٍ مِّنْهُمَا تَارِيخًا. If both of these claimants had also presented a date, right? And one of their dates was earlier. So if their dates were exactly on the same time, same date, then obviously it doesn't benefit. So it's going to be the same case. They're both going to get the right. But if one's date is earlier than the other person, فَهُوَ لِلْأَوَّلِ مِنْهُمَا, then obviously it's he gets the right to take the full amount, right? Because he's obviously establishing that he purchased at a time when the other person has no claim to it. And then the other person claiming afterwards, but it's already this guy's. But the person is not claiming from him, the person is claiming from the other person, right? So if he turned his claim on him, on the first person, on the first claimant, then that would be another case. So what about if the case that one person provides date and the other person doesn't provide any date at all? Then obviously that person who provides the date gets it, because he's actually providing something extra, something solid, right? And it shows that that person has it from that particular date, whereas the other person who has no date, then we can't extend his date we can't backdate him. All we can say is that according to your proof, you own it now, because when you don't have a date, then it's just going to have to be the closest moment, whereas the other person's date is 1st of July, 2 months ago, for example, right? And this person's date, because he doesn't have one, all we can establish that your date is now, but 1st of July was earlier, so he gets it. Now, if وَإِن لَمْ يَذْكُرَا تَارِيخًا, if they actually don't mention any date, وَمَعَ أَحَدِهِمَا قَبْضٌ, but one of them actually has the slave, one of them has the item, right? And it's a claim of I bought it, I bought this, both of them are claiming the same thing, but one actually has the possession. So now remember, both of the evidence are equal. So now we need something to give precedence. And in this case, we can actually use this, because we can actually use the fact that person A had possession. We can use that to actually supersede and give preference to his claim. You might say, but we just read earlier that the person with possession doesn't get anything in addition. It's the other person whose evidence becomes stronger. That was only in the case where it's just a simple claim of this is mine. Here it's not a simple claim of this is mine. It was a claim of I bought it from that person. I bought it from person C. So it's about a claim of purchasing it from somebody, not just mere ownership. That's why in this case, the fact that it's in his possession as well adds to his proof, right? So inshallah, when we learn a few more of these, you'll start getting an understanding of how this whole works, and there's a very clear logical system. Okay, then he says, وَإِنِ ادَّعَى, two people are claiming, أَحَدُهُمَا شِرَاءً وَالْآخَرُ هِبَةً. So again, it's person A and B and person C. Person A is saying, this book, I bought it, I purchased it from person C. Person B is saying, no, he gifted it to me. So they're both claiming an ownership, and they're also claiming a reason for that ownership. Purchase and gift, which is stronger? Purchase or gift, which is stronger? The stronger one is the gift. The stronger one is the purchase, because it's from both sides. There's a pure intent there. It's not like a one-sided goodwill gesture where the other person has just then accepted it. So he's saying, وَالْآخَرُ هِبَةً وَقَبْضًا. So one of them is just saying that I purchased it, but he doesn't have possession. The other person said that he gifted it to me and I took possession of it. They both establish proof and witnesses for the two means, but they have no date, right? There's no mention of any date as to what date that the sale or the gift took place. For shira'u awla. So in this case, the purchase is going to be more rightful, right? Because purchasing something is more stronger than getting something as a gift. Why? Because it's a mutual agreement on both sides where something is given and taken. Whereas in the case of a gift, it's only gifted from one side and the other person just takes it. He doesn't give anything in return usually, right? So there's reasons for that. Now, the next issue is وَإِنِ ادَّعَى أَحَدُهُمَا الشِّرَاءَ one of them claims to have purchased it. وَادَّعَتْ إِمْرَأَةٌ أَنَّهُ تَزَوَّجَهَا عَلَيْهِ, whereas the second person is a woman who is claiming that that is mine, I got it from him because he married me for the price of that. That was the mahar, that was the ransom. Then in this case, because it's the marriage, that item being a dowry is similar to a purchase, because it is an agreement from two sides where it's a give and take from both sides, right? There are two counter things which are being, exchanged. They're both equal in that case. So you're going to need something else to give preference to one of them over the other. Right, to complete a few more issues in this last part of the session. وَإِنِ ادَّعَى أَحَدُهُمَا رَهْنًا وَقَبْضًا. So one of them now makes a claim that this is mine, I'm holding on to it because he gave it to me as a security. I lent him £1,000, so he gave me this laptop to hold as security, so that's why it's in my hand. It's mine based on security, meaning it's mine right now until he gives me £1,000 back. The other one is saying, no, he gifted it to me and I took possession of it as well. So which one is superior in that case? The rahan is superior, right? The collateral is superior, even though in the collateral it doesn't become fully his. He's just holding it as security. It can become his if the other person refuses to give him back his owed money, right? But in that case, it's stronger, right? Actually the gift aspect should have been stronger. According to the normal default understanding here, that should have been the stronger part. He should have gotten preference for it. But because there's a liability on this case, this is what they call an istihsan ruling, where they, for a subtle reason here, that because it's got a liability here. It wasn't just gifted like that. There's a liability here. We're going to give precedence to that. Otherwise, it's going to cause a lot of issues here, because in the case of hiba, there's no liability. It just becomes yours. You can do what you want with it. Whereas in this case, there's liability, right? So yeah, just a few more to finish off now. وإن أقام المدعيان الخارجان البينة على الملك والتاريخ المختلف فصاحب التاريخ الأبعد. This is the case where it's just a claim of ownership, and there's two people who don't have anything in their possession, who don't have the item in their possession. They're both claiming for it, and they both have different dates. One is saying that I got it, it became mine on the 1st of February. The other one is saying it became mine on the 1st of March, right? So obviously for صاحب التاريخ الأبعد, the one who has the earlier date, the further date, أولى, he is more rightful to it. He will get it, right? Because he's obviously proving that he was owner before the other one. That's essentially why, right? And وإن ادعي الشراء من واحد أي غير ذي يد لئلا يتكرر مع ما سبق وأقام البينة على التاريخين. If there's two people who are claiming from a third person, and this third person doesn't have the item, but they're just claiming that it's mine, and the other person from that person, right? And they both establish evidence as well on two different dates, right? Then obviously whoever has the first date. So when the case of two dates, and if everything else is equal and they have two separate dates, then usually the earlier one is what is going to be more rightful, is the one is going to be more rightful, because the date that he's establishing, 1st of February, there's no competition in that one. Whereas the date the other person is establishing, 1st of March, there's a competition already that the person in February took it. So that's why we're going to go with the one who didn't have any competition. It must be his from then, right? So I hope that's clear. I hope we're getting somewhere with this. We're getting the understanding of how to juggle between two. Now, all of these cases I've mentioned so far, or not all of the cases, but many of the cases we mentioned are the more complicated, because the simple cases where there's not two people claiming, then those are the simple cases. Those will be the majority. But he's now dealing with the more complicated, more seldom cases where there's two people claiming something. Then this is how you will give preference between them. Inshallah, we'll see you in the next class. Allah bless you all. Assalamu alaikum.